All right, good morning, everyone. This is Judge Adam Torum. I'm an administrative law judge appointed by the Energy Facility Site Evaluation Council of Washington, or EFSEC, to preside over the application filed by Scout Clean Energy, LLC, on behalf of the Horse Heaven Wind Farm, LLC, and the adjudication that's going to go forward in the months ahead on this matter. Today, we are doing our first pre-hearing conference since we issued the order commencing adjudication back on December 15th of 2022. We've also had a chance for people to file their petitions for intervention, and yesterday issued a preliminary order on intervention that we'll cover as the second agenda item for today. Again, for the record, today's date is Friday, March 10th, 2023. It's now 9:02 a.m. We were scheduled to begin at 9, and I hope all the parties were online as I was talking with the court reporter during that opening minute of the hour. We'll plan, per the court reporter, to take breaks every 45 to 50 minutes and take a 5 to 10 minute break as needed for comfort. So plan for that at about 9:50 today, and during the second hour, if we go that long, again at about 10:50. We have a number of parties that I want to take a roll call on, but again, I want to state for the record, if you're a member of the public or the press, or just an interested person wondering what does EFSEC do, today's matter with the Horse Heaven Wind Farm project as proposed is simply to get scheduling done and talk about disputed issues. It's really an organizational meeting. So if you will understand that this is not an opportunity for public comment, it's not the sort of meeting where we invite people who are not parties to the upcoming trial or hearing, formerly known as an adjudication, to participate. So please don't expect for a public comment opportunity. That opportunity will come at a later date, and we'll be giving well advanced notice about when that will be. Let me start with the roll call for the applicant. Mr. McMahon, are you on the line?
Yes, I am, Your Honor. Can you hear me?
I can hear you, Mr. McMahon. Good morning. Who else from your team at Stoll Reeves is on the line?
Yeah, again, Tim McMahon with Stoll Reeves, and with me is Crystal Chase. She is a natural resource litigator who will be working on the proceedings along with Emily Schimmelfenig. It's a tough one for me still. Emily will be assisting us throughout the proceedings as well.
All right. And are both of those colleagues on the line with you today?
Ms. Chase is, and I believe Emily is on the line from afar.
All right. And will you be taking the speaking role today on behalf of the applicant?
Your Honor, thank you for that. I believe Ms. Chase will take the lead for the morning. I may jump in here and there as you will tolerate, perhaps, particularly if there's any history relating to land use issues and the like, but I will certainly take your guidance on whether or not I should be participating.
It's fine. I don't think we need to have a one lawyer, one witness type of rule for today, but I'm just looking for who I should call on for each party. Great. Thank you very much, Mr.
And that would be Ms. Chase.
Ms. Chase, let's test your microphone and see if we can hear you.
Yes, good morning, Judge Torum. This is Crystal Chase.
All right, we can hear you loud and clear. For Benton County, the law firm of Menke Jackson Buyer LLP is representing them. Do we have Kenneth Harper?
You do, Your Honor. Good morning.
Good morning. Thank you, Mr. Harper. And is it Aziza Foster, or did I butcher the name?
No, you got that perfect, Your Honor.
Excellent. Which of you is going to take the lead today for Benton County?
I will.
And that's Kenneth Harper?
Yes.
Great. And the court reporter is going to have a hard time knowing who's speaking if we don't identify ourselves. So it's a little bit burdensome, but when you first start jumping back in, if there's a back and forth, it'll be helpful if you identify yourself, and that'll make a cleaner record of today's proceeding when we go back. Mr. Harper, I note that Brian Brown was the Benton County prosecuting attorney who participated in previous proceedings prior to your notice of appearance. Is Mr. Brown on the line or participating today?
Mr. Brown will not be participating. I think we may have Deputy Prosecuting Attorney Jeff Altman on the line for Benton County as well, though, Your Honor.
Good morning, Your Honor. This is Jeff Altman. I'm going to be attending this. I don't think I'll have any substantive participation in this. Mr. Brown had a family emergency, so he unfortunately can't be here.
Thank you, Mr. Altman. I'm sorry to hear that on behalf of Mr. Brown, but appreciate that someone from your office is monitoring what's going on, and I'll defer to Mr. Harper when I call on Benton County. Our next statutory party is the Council for the Environment. Assistant Attorney General Sarah Reineveld should be on the line, I hope.
Yes, good morning, Judge Torum. This is Sarah Reineveld.
Good to hear your voice, Ms. Reineveld. Anybody else from your office participating today?
No, it's just me. Thank you.
All right. Turning now to our interveners, the Confederated Tribes and Band of the Yakama Nation. There are 3 attorneys from the Yakama Nation Office of Legal Counsel who filed their notice of appearance. Do we have Ethan Jones?
Yes, Your Honor. Good morning. Ethan Jones on behalf of the Yakama Nation.
And I don't know if it's Shona or Shauna Velkers.
Good morning, Your Honor. Shona Volkers on behalf of the Yakama Nation, and I will be taking point for our team this morning. My colleague Jessica Houston is also joining us today.
All right. Ms. Volkers, thanks for the help on the pronunciation. I appreciate it. And please correct me if I defer back to my initial error. All right, and Ms. Houston, I take it you don't have a speaking role, but let's check your mic just to make sure in case there's something you need to pipe in on.
Good morning, Your Honor.
All right, good morning, Ms. Houston, thank you. Our final intervening party is Tri-Cities CARES. It's an acronym, CARES. And for the record, I understand it to mean Community Action for Responsible Environmental Stewardship. Their attorney is J. Richard Arambaru. Mr. Arambaru, are you on the line?
Yes, good morning, Your Honor and parties. Richard Arambaru representing Tri-City CARES.
All right, thank you, sir. Were there any other attorneys or parties on the line whom I did not call? Hearing none, I wanted to identify what other EFSEC staff are on the line, and then perhaps, just so everybody's aware, if there are members of the EFSEC Council, I'll ask them to identify themselves as well. Do we have John Thompson, our Assistant Attorney General?
Yes, I'm present.
Excellent, thank you. And a couple of key members who are monitoring things. Lisa Massengale.
Good morning, Your Honor.
Good morning. Andrea Grantham.
Andrea Grantham is present.
All right, and Andrea and Lisa are busy monitoring the microphones here on Microsoft Teams this morning. They're going to be muting folks that they might see active microphones when it's not appropriate. So if your dog starts barking, or as the hazard in my home is cats start rioting, they'll do their best to minimize the background noise so Miss Allison, our court reporter, can keep a clean record here. Do we have any EFSEC Council members?
Ed Brost is on.
Excuse me, Ed Brost?
Yes.
And Mr. Brost, you're representing Benton County, right?
Yes, sir.
All right, well, welcome. If you have any questions along the way or afterwards, feel free to reach out to me, and we can clarify anything that you need to take back to your folks there at Benton County on behalf of your time at the council. Any other council members? All right, hearing none. Any other staff members from EFSEC who want to identify themselves? I know I don't have any responsibilities assigned to any of you, but is anybody else listening?
Joan Owens.
Oh, and Judge Torum, this is Amy Moon.
All right, thank you both for being here.
It's Sonia Scapland.
Sonia, welcome.
Yep.
Sarah Randolph.
I'm sorry?
Sarah Randolph.
Sarah Randolph. All right, that's Sarah, you're new to me. I'm sure I'll find out what you do at the council soon.
Thank you.
Any other staff members? All right, that takes care of the roll call unless there's anybody else who wants to speak up now and tell me they need to be counted in our attendance today. All right, Ms. Massengale, I'll ask that you advance the agenda to page 2. No, the second agenda item that's on your screen now is our preliminary order on intervention.
Good morning. This is Crystal Chase for applicant. I am not able to hear Judge Torum.
I'm not either. This is Sarah Reineveld from Council for the Environment.
This is Lisa Massing at EFSEC. Yes, Judge Torm, it appears we have lost your audio. And I will go ahead and send Judge Torm a message letting him know we have lost his audio as well, in case he's having trouble hearing us.
This is Judge Torum. Am I back in the meeting by phone now?
This is Lisa Massing at EFSEC. Yes, we can hear you, Judge Torm.
I don't know, mid-sentence, Teams just dropped off my screen, went blank when I asked you to switch to page 2 of the agenda. So I apologize to everybody for doing a quick disappearance there. We'll pick up with that agenda item number 2. I've got my own copy of the agenda on my computer screen here, so I will follow along with you. I think I was about to say that we issued our preliminary order on intervention last night. It unfortunately came out after 5 o'clock, so I apologize for the late breaking news on that. My intention originally was that it would come out earlier in the week, and things got ahead of me. So I'm human too. There's only 24 hours in a day, but you have the decision preliminary order on intervention granting the petition filed by the Yakima Nation. There was no objection to the Yakima Nation's petition or its requested scope of intervention. Tri-Cities Cares, also their petition is granted. There is the matter of the applicant's indication that they had some limited objections regarding the scope. I held a reservation in that order that we would deal with any scope of intervention questions following today's proceeding and perhaps after another pre-hearing conference if necessary. Really was dependent on how the discussion went today and how I can see Mr. Aramburu on behalf of your client, how to best figure out exactly what issues you'll be focusing on and other issues you might not be participating in. So we'll address those things later, perhaps in today's conference and perhaps in an additional one. Mr. Aramburu, did you have any questions? Because I know you responded to the applicant's opposition as well.
Judge Torm, we have responded. I believe you have a copy of that response, and it's been provided to the applicant. Just this morning, we sent to you and the parties a bit of an update with some more information concerning our issues, and so we're prepared when you're ready to discuss additional intervention issues. As you know, we're requesting full party status in these proceedings.
Thank you, Mr. Aramburu. I'll confirm I did get the email this morning, and frankly, I wanted to give you props for actually listing issues that were specific to some things raised in the application and the environmental studies so far. I want to assure you that Tri-City Cares is a full party intervener status. It'll just be a real question as to what topics you might or might not be participating in. For all parties, there may be some focuses that you say, oh, that's an issue that I won't be presenting testimony on, or our clients just as simply, that's not what they are worried about or concerned about as we process this application. If those items come up when we get to that part of the agenda, in my experience with these wind farm hearings, or generally with complex litigation, knowing which parties don't want to comment is helpful for scheduling. As Mr. Aramburu, you have some dates of unavailability. It might be that the hearing proceeds on a topic that's not of concern to your client on days when you're not available, if we feel that time constraints require us to keep going without all the parties present. But again, that would be by agreement and hopefully not by anything just dictated by Judge Torum out of what he thinks is the right thing to do. But we'll have a full discussion before we do anything like that. Mr. Rambrou, any questions about what I said about full party status and dealing with those things?
No, Your Honor. We're prepared to participate in further discussions about scope of intervention at your convenience.
Perfect. We may get to some of that today. All right. The next item on the agenda is the venue for this adjudication. When I asked the parties before intervention was granted, and when I asked the parties through Mr. McMahon at Stoll Reeves to round up everybody while petitions for intervention were pending and have some collaborative discussions with the county and with Council for the Environment, I got a letter on March 1st that's posted on the EFSEC website, and I think it's an input on procedural considerations for our adjudication. There's a number of things addressed in there regarding pre-filed testimony and some of the items for exhibits and briefing schedules. What I wanted to start with was the venue. Our chair of the EFSEC Council had indicated that this was going to be a virtual proceeding. Personally, I'm not a fan. As you could see with my interaction with Microsoft Teams, technology can be, through no fault of your own, tweaky depending on your equipment, your broadband connection, or what the weather might be doing that day. So I wanted to at least survey everybody today, and I'll call on each of you to tell me your preference for your clients on how we go about conducting this proceeding. I'm the presiding officer and not the deciding officer on this matter, but I can take your inputs back to Chair Drew and let her know what our clients at EFSEC really want to do on this matter. So, Ms. Chase, let me turn to the applicant. How would the applicant prefer this adjudication be held? And the options that I put on there were in-person, virtual, or some kind of hybrid.
Thank you, Judge Torum. This is Ms. Chase on behalf of applicant. Applicant would prefer to stay with EFSEC's preliminary determination of a virtual hearing, with our second preference being a hybrid hearing for flexibility of witnesses and parties. Thank you.
All right. And for the county, Mr. Harper?
Ken Harper for Yakima, for Benton County. Your Honor, I share some of the concerns you've raised. I frankly would prefer an in-person hearing. There's some appeal to perhaps splitting the difference and saying hybrid. I don't feel strongly about that, but the county does have an interest in a significant in-person component.
All right, so if I heard you correctly, Mr. Harper, the county would prefer in-person, but perhaps some blend of a hybrid could also be worked in.
That's correct, Your Honor.
All right. Ms. Reineveld, how would the Council for the Environment think best conducted?
The Council for the Environment would prefer a virtual hearing, but we are open to a hybrid hearing to accommodate the preference of Yakima Nation and other parties that would like to present testimony in person. It was our understanding that this was going to be a virtual hearing, and so therefore, I live in Seattle and I'm not prepared to travel back and forth to the Tri-Cities, and I just wanted to state that it would be burdensome for many of our team to do so. But we also, would be in favor of a hybrid model to accommodate the preferences for in-person testimony.
All right, thank you, Ms. Reineveld. Ms. Volkers, on behalf of the Yakima Nation, let me hear from you.
Thank you, Your Honor. Shona Volkers, Council for Yakima Nation strongly advocates for an in-person hearing due to the nature of the issues that we have already identified, as well as others, the sensitivity of the information that we hope to share with the full council, and the need to have that happen, if at all possible, while we're all sitting in a room, and so that our witnesses can bring the information that they have in a way that is sensitive to what they have to share.
Thank you, Ms. Volker.
Go ahead.
Your Honor, if I could, if the decision is to have a hybrid proceeding, as I'm hearing others advocate for, the Yakama Nation would intend to still participate fully in person to the extent that you allow.
Ms. Volkers, I'm looking at page 2 of the letter that came from Stoll Reeves on March 1st and signed by Ms. Chase and Mr. McMahon. There's a paragraph there where they represented the following. Concerning live testimony, the Yakama Nation is requesting the ability to bring direct oral testimony by Yakama Nation members during the hearing. And the testimony would be limited to cultural resource impacts of the proposed project. Can you share with me just a little bit more what you see in your mind of how that would occur?
Yes, Your Honor, thank you. This is Shona Volkers again on behalf of the Yakama Nation. So first, during that conversation with counsel and as captured above that paragraph in Ms. Chase's letter, the Yakama Nation does intend to participate fully through the written testimony process when we can. And it's just asking to have the ability to bring direct oral testimony by Yakama Nation members who will be elders during the hearing, rather than being limited to the oral testimony or the live portion of the hearing, rather than being limited to just rebuttal or supplemental testimony. So the request is that the Yakama Nation members, elders with knowledge of the oral traditions of the nation that are not comfortable engaging in written testimony, still be able to bring that direct testimony in the hearing itself. And outside of that scope, we would be, for any other witnesses, certainly we're prepared to engage in the written testimony process outlined in Ms. Chase's letter.
Thank you, Ms. Volkers. If I'm understanding you correctly, and again, please correct me if I'm wrong, you have members of your client Yakama Nation who are elders, feel that it's best for them to avoid any written format or technological means to transmit their feelings, opinions, and knowledge to the Energy Siting Council, and they would like to do it by standing personally in front of someone to hear what they have to say using the oral tradition of transmitting that knowledge. Is that correct?
Yes, that is, I think, a fair summary. And I would say the knowledge is carried orally, and we understand that that this is still a public proceeding, and we are just asking for the most protections possible and the most sensitivity to the sacredness of the information that may be shared.
Yes, and I have great respect for that and want to make sure that I'm understanding what you're asking for. So if I can provide that type of venue for those elders to give their testimony and transmit that knowledge for the council's consideration, we can. Would there be a need in that presentation for an interpreter, or would the Yakama elders be speaking in a language that the council could understand?
I would anticipate, Your Honor, this is Shona Volkers again. I would anticipate that our witnesses would speak both in English and in their own language, but that we would not be requesting an interpreter.
All right. In my experience as a judge and working with court reporters over the years, the record that's created would only be in English. So that portion of the oral history and knowledge that's given in any language other than English, particularly if not using an interpreter, would be lost to the record for appeal in this matter, unless you can come up with some other way and recommendation for it to be captured. In my creative mind, I could see a video being made. However, I understand that capturing live images of some First Nations or tribal members might be seen as offensive. I don't know the traditions of the Yakama tribe, and I can't pretend to guess what they might be. So I will need your help in trying to determine if in-person testimony is permitted, and if an oral presentation from a Yakima elder is permitted, how that can be captured for all that may not be present for the original talk and may not be able to review a video or a transcript of it if it's done in a language other than English. Ms. Volkers, do you understand that dilemma that an ALJ trying to put together a record has with this sort of request?
Thank you. Thank you, Your Honor. Sorry, Shona Volkers again. I do understand the dilemma. I think if it's helpful to explain it a little more, I think that where a witness wants their words translated onto the record, they will do so in English as well. And where they do not, they will choose not to translate it for us. I am not currently working with any witnesses that cannot translate their own testimony into English if they choose to do so. And would need additional time as we are working with folks to follow up on your question about a video recording, because each member has a different level of comfort with this process.
All right, thank you. I think that's all the questions I have about the Yakima Nation's request and for the reason behind the in-person testimony. Was there anything else you think you needed to tell me and to be captured on today's record?
Thank you, Your Honor. Shona Volkers again. We also anticipate that the use of exhibits will be, if not significantly, at least measurably impacted by having a remote hearing. And that's based upon our experience with these types of proceedings over the last number of years before both the Pollution Control Hearings Board and the Growth Management Hearings Board.
Okay, understood. Fair enough. Thank you, ma'am. I'm going to turn now to Mr. Arambaru on behalf of Tri-Cities Cares and come back to the original question. We're still on item number 3 on our agenda. Mr. Arambaru, how would your client like to see this proceeding and adjudication go forward?
Thank you, Your Honor. Richard Arambaru for Tri-City Cares. We strongly support an in-person hearing for several reasons. First of all, this gives the opportunity for the public who are interested in this matter to attend without having to use all of the electronic materials and see the council in action as they are reviewing this. The second issue, which is equally important, is the ability to understand drawings, maps, diagrams, and other things on a limited screen. We're all this morning looking at a small screen, and Judge Torm, I can read your material, but this is a very, very large project. There will be multiple maps, there will be multiple pictures, there will be multiple drawings, and it is very hard to address those issues if it is done on the small screen. And in addition, it will be difficult for council members to pose questions of witnesses, which they are entitled to do and often do, based upon this kind of format. In our prior experience in the Whistling Ridge matter, we had a large room. We had probably a 12 by 12 screen that we could put up maps, photos, even some text, pictures, and everyone could see them at the same time, and parties could ask questions about them, can use a pointer to use these materials. So in something that is as visual as a hearing like this, and this is a really, really big project, so just trying to portray the whole project on the screen presents its problems. So for those reasons, we think that the in-person hearing somewhere in the project vicinity is appropriate and I think useful to the council members. I know there's concern about travel. There's concern about time of individuals, but I think the parties would be able to get together and finely tune a schedule, and this will be principally cross-examination, a schedule so that time can be used efficiently during that cross-examination period. So I've gone on a bit longer than I should, but we very much strongly support the in-person hearing. And we also want to reserve the possibility that maybe one or more witnesses might be able to give on an in-person hearing kind of a brief statement. We're talking here about pre-filed direct testimony, and we're in support of that. But on certain issues, and there's no question that visual issues are important to us, it might be good, we might ask that a witness be allowed a presentation during the course of the hearing to show the photographs and other visual materials as a supplement to the testimony. So that's kind of a second reason to have a in-person hearing. So sorry I went on so long, but these are important concerns.
No, thank you, Mr. Aramburu. I thought about interjecting when you got to the testimony question, but I see how you tied it in to the overall answer on venue and what's appropriate. I do understand that for some witnesses, the pictures really are worth 1,000 more words. So I will take that under consideration. So I have a tally voting of 3 parties wanting in person, 2 wanting virtual, but open to hybrid. Again, it's above my pay grade here as what's delegated authority to me to choose the venue. I know what I will lobby for is to be in person and or have a hybrid for those that choose or are not able to travel. I want this to be as open as possible. I personally made a promise that I hope I can follow through on to the people of Benton County to bring the council to the county where this project is proposed back at the informational meeting and land use hearings that was, believe it or not, were at least 2 years ago, or well, at the end of the month, it'll be 2 years since we held those proceedings. But if you check the transcript, you'll find me having some words I may have to eat about promising to be next in Benton County. I will talk to the chair. I will see what Chair Drew wants to do, and her decision will be final. I don't know that there is any interlocutory review once the chair of the council makes a decision. So we've created a record today. I've given all parties an opportunity. I will ask the chair to review the transcript, and then I will lobby accordingly, and we'll see what we get. I'll report back when I can. Are there any questions? I'll go around the table again about the venue question. Ms. Chase?
Good morning, this is Ms. Chase. The only comment that I would offer, Judge Torum, is that there may also be an opportunity, and as we discuss the different issues later today, to have some of the testimony held in person, for example, the items that Ms. Volkers was discussing in order to accommodate those concerns, and schedule other portions of the proceeding virtual or hybrid. So I'm just flagging that we may have an option for some depending on if we end up with staggered portions of the proceeding as to how this is venued. Thank you.
Thank you, Ms. Chase. And I do believe that some days of hearing will better be suited for a different type of venue. Some may be suited simply for virtual. If we have like opening statements or some kind of arguments or a motion practice, I think we've all gotten used to over the last 2 or 3 years doing things by phone, by Zoom, or even by Microsoft Teams when I can make it work. For the county, Mr. Harper, any last comments on the venue question?
Ken Harper for the county. No, thank you, Your Honor.
Ms. Reineveld?
I don't have anything further. I agree with Ms. Chase's comments, though. Thank you.
Ms. Volkers, anything else from the Yakima Nation?
Thank you, Your Honor. Nothing else at this time.
Mr. Aramburu, a last bite?
I think there are certain witnesses in certain parts of the proceeding that could be virtual, but we think most of the hearings should be in person. Thank you.
All right, thank you. You've been clear on that. Let me give staff a chance if they want to chime in on anything that I may not be aware of. Mr. Thompson, anything from your perspective that I didn't cover on the venue question?
No, nothing I can think of.
All right. Anybody else from staff for EFSEC that wants to jump in with a consideration that I may not have brought up to the parties? All right, you're going to let me go before the chair myself. I appreciate that, EFSEC staff. Let's move on to number 4. We have about 15 minutes before our first break. If you had a chance to get today's agenda, and I'll read it for those that may not have it on the screen or have received it. Back on September 27th, the applicant for this project filed what was a second extension request, and they obtained EFSEC's agreement that the processing time for their project for the Horse Heaven Wind Farm be extended out to July 8th, 2023. That date is important, and it's important because EFSEC under RCW 8050, particularly section 100, and I'm going to say this is a notional deadline, we're supposed to complete all of the review and make a recommendation to the governor within a 12-month time period. And if that doesn't occur, applicants can ask for an extension. I'm not certain that in the history of EFSEC, any project has ever gotten through in the 12 months if it required an adjudication. Some that got expedited processing and some that had very easy to determine environmental impacts that had maybe a mitigated determination of non-significance in the SEPA review may have. But in my experience, if there's an environmental impact statement, a full EIS required under SEPA, the 12-month statutory deadline is frankly a legal fiction. Nevertheless, it's important that an applicant should be able to expect EFSEC to act vigorously and promptly to get the review done. So with that in mind, once we saw that the draft environmental impact statement was getting ready to be finalized and published at the end of 2022, I asked that staff survey the council members, including Mr. Brost, who's on the line today, to provide us their calendars and when they were absolutely unavailable for the spring of this year. Once we figured out the timeline about when this pre-hearing conference would be held, we figured the rest of March, we wouldn't be holding a hearing. We asked them for April, May, and June, and all the way up to that July 8th notional deadline that exists now for the application to be considered and a recommendation made to the governor. I can't say whether July 8th is the absolute deadline. The applicant has a lot of say in that, and so does the council, but that's why I have presented number 4 in the fashion it is on your agenda. If you look at the bullet points listing out 5 separate weeks, you'll see starting in the middle of May, we have a full week, and we have the following several weeks, except for the holidays of Memorial Day and Juneteenth, which fall on Monday, May 29th for Memorial Day, and Monday, June 19th for Juneteenth. Those weeks were available for most of the EFSEC council members. If an EFSEC council member is not able to attend a hearing session, we require them to read the transcript of that proceeding so that they can get the full record before we get to the part of the adjudication where the council will deliberate on all the evidence they've heard, make their evaluations, and then ultimately that recommendation to the governor. So the scheduling that's here, I want to have Ms. Chase, you speak a little bit to what we'll be talking about more in item number 6 about the schedule for pre-filed testimony, and just to know what the applicant has been thinking about gathering its evidence in support of the application, and when you think realistically the first possible date after today that pre-filed testimony could come in from the applicant, which would trigger some of the other, I think 28 days later, the other parties might file responsive testimony. So a starting point, if it's past May 15th for filing the testimony, clearly the hearings couldn't occur on or before that date. Ms. Chase, is that clear what I'm asking, if you know?
Good morning, Judge Forum. Thank you for that framing of the issues. This is Crystal Chase for applicant. I think it would be, I'm happy to answer those questions, but I think one clarification that would be helpful is to understand the expectation of the scope of the initial round of written testimony to be presented by applicant. In other words, if that pre-filed direct testimony would be limited to sponsoring relevant sections of the application and qualifying witnesses, or if you intend a greater scope. And I ask that question only because it will help inform the answer that I give you in terms of a realistic deadline.
Well, Ms. Chase, as you might expect, as someone with a legal background, it depends. I'd like to say that the scope of what I'm asking you is at least what you said, the sponsoring various portions of the application and having the relevant witnesses. Once we really get to the end of today, or maybe an additional pre-hearing conference, and we've got the list of disputed issues established and either agreed to or at least ordered by me, when those are done, then we'll know what the scope of testimony supporting all of the list of disputed issues is. So I won't hold you to your answer today, but at least as a starting point, as you said, the applicant should be prepared to sponsor testimony explaining various portions of the application, and as updated, what the currently proposed project will be, and all of those other environmental issues that we are pretty certain are going to be disputed or need some further testimony. Perhaps there are some portions of the application that will stand on their own without any testimony and can come in by some sort of stipulation. But for all of the statutorily and regulatory rules, requirements on how the record is created on which the council makes their recommendation to the governor, I'd expect the applicant to be ready to put some sort of testimony forward. And I know Mr. McMahon has done that when I've been the judge in the Kittitas County, 2 different wind farms here, and so I've watched him do it in other proceedings in other parts of the state. So with that in mind, Ms. Chase, I think you know at least the minimum of what you're going to be putting forward. When would that be ready?
Sure, Judge Torm. So I would say the week of April 3rd, we could certainly have that ready. I was thinking about the prior week, but I know that it is spring break for some folks, and I want to be cognizant of witness availability and not imposing on pre-scheduled vacations for others.
Well, I'm gratified to hear that the month at least was April, and you gave me an early time in April for that. Thank you. Do you think that anybody else will be filing materials in support of the application along with the applicant? Are there any other parties, Ms. Chase, that you're aware of that you'll be having, or is the applicant essentially carrying the water on this, and it'll be all of their witnesses, and the other 4 parties will be in response to varying issues per their own interests?
So Judge Torm, this is Ms. Chase, and I anticipate that applicant would likely be the only party that meets that category. I don't want to preclude any other parties that may have a different view from speaking for themselves, but that's what I would anticipate given our discussions to date.
All right, and when I come around to each party, if they have an issue they are a proponent of, I'm sure they'll let me know. But I'm certainly not expecting necessarily, given what I've read in the petitions for intervention and the notices of party participation. All right, April 3rd. If we look at that, Ms. Chase, can you call my attention back to where the time intervals were in the letter? I think it's on the top of page 2 of the March 1st letter from your office.
Yes, that's correct. So the proposed intervals were 28 days for reply testimony and 21 days for rebuttal testimony. And I'll just add that I think the parties, I know that we included in the March 9th letter as well, that I think the parties would appreciate clarification on when a party who is a proponent of a specific issue, but perhaps not in support of an application, at what point in time in that 3-tiered process they would be expected to submit their testimony.
All right, thank you, Ms. Chase. So for the other parties that are keeping score at home here, as I look at my calendar, if April 3rd is a Monday, and notionally, if we said that as a deadline for the submission of pre-hearing and pre-filed testimony from the applicant, based on whatever list of disputed issues we can get done, 28 days later would be May the 1st, and 21 days following that would be May the 22nd. So if we go back to our agenda and the time period, the May 1st deadline, I think, Mr. Aramburu, looking at your notice of unavailability, yours would have started on May 8th to 18th, and you requested that not having to respond to anything during that period. If I can keep the reply testimony deadline on or before May 8th, then perhaps we won't have to worry about that first block of time when you can't respond to things. Mr. Aramburu, is that correct?
Yes, we have some other concerns about the schedule, but yes, and I apologize that we have preset times to be out of the office here on the dates we have. So if something came in before my scheduled time out of the office, then I think the problem I have with that is that if something comes in, so April 3rd, so May 1st would be the time schedule then for reply?
Yes, Mr. Aramburu, I'm just doing the math on the 28 days that was set out in that letter from Stoll Reeves dated March 1st. What I'm frankly thinking, sir, is that the April 3rd date, early as it is, may not be realistic. That might even slide by 7 days or thereabouts. Maybe it only slides by 4 days to the end of the week. If we have to conduct another pre-hearing conference in this matter, which I fully expect, and depending on the timing of that and the finalizing of the disputed issues list, the applicant's filing of the testimony would then trigger the response or reply need from all the other parties, including Tri-Cities Cares. So I'm just thinking about all those issues out loud here, always dangerous, but it gives us something to work with today. Understood?
If you're still speaking with me, Mr. Durham, yes, that timing is understood. We have some very serious concerns about the schedule, though.
Correct. I'm just getting the notional thing out there, so then we have probably after the break, Mr. Aramburu, all those other issues can be aired out. And I'm not pretending those are going to be simple whatsoever. All right, so Ms. Chase, I just, on my notepad here, I've got the April 3rd to May 1st to May 22nd interval, and a more full answer to your other question, what does that mean for the other parties? My thought is if the applicant were to file first on whatever interval date we choose, then 28 days later, if it's acceptable to all, on this calendar, May 1st, reply testimony would come in on the issues for each party on which they want to respond to any or all of the applicant's testimony. And then in the next interval, 21 days later, it would simply be the applicant responding to all of the reply testimony and perhaps other parties responding to each other if they differ. For instance, Tri-Cities Cares may take a different position on something than Benton County, and they only see each other's testimony on that second filing date. Perhaps the Yakima Nation files their testimony, knowing also that it's going to be supplemented, if allowed, by oral testimony and oral history, and they may be able to give us a preview of what that is. But when they see other parties' reply testimony, they may also wish to file the rebuttal testimony to other parties. So it gets a little bit convoluted, but for a full due process in this kind of complex litigation, that's the kind of thing that may happen once we open this can of worms and let the first round of testimony come in. We know who's expected in the second, but the third round can typically be a little unpredictable. Sometimes that results in motion practice to strike things that may not be seen as relevant by another party, and that's where my job gets a little bit more difficult. But that's why I love this stuff. So It is now 9:51. I promised a break. Hold all the thoughts you have, please, on scheduling and the intervals. And I'll ask Miss Allison if we come back at 10 o'clock on the nose and do a quick roll call. Would that be satisfactory to you?
That's fine.
All right, so we're going to take a brief recess. Please mute your phones so that no undue noise comes through, and we'll come back on. I'll make sure everybody's back at 10 o'clock. Thank you. Thank you, ma'am. I'm now going to do a quick roll call as we come back in the second hour of our first pre-hearing conference, and just put those that identified for the parties as the speaking roles, see if they're still here. Crystal. Kent.
Good morning, this is Ms. Chase, I'm still here.
Kenneth Harper for Benton County.
Ken Harper for Benton County is present. Thank you.
Sarah Reineveld, Counsel for the Environment.
Sarah Reineveld, Counsel for the Environment, present. Thank you.
Shona Volkers for the Yakima Nation.
Shona Volkers for the Yakima Nation, present, as well as my colleagues.
Thank you. And for Tri-Cities Cares, Mr. Richard Aramburu.
Your Honor, Richard Aramburu here for Tri-City Cares. Thank you.
All right, and I'm not going to call all of the staff members again for EFSEC. Kind of been communicating with them offline. Let's pick up where we were on the scheduling questions. I think where we left off was just trying to sort out what would have to be built in before we could possibly do the adjudication. And that would be the filing of testimony, maybe some motion practice and some other things. And at a minimum, it looked like that could be done by May 22nd. That would be the earliest possible date. Maybe by May 30th if we shifted the testimony filing dates out or expanded them some. But it sounds like no hearing time could possibly be scheduled until at least the week of May 22nd, more likely after Memorial Day. And Mr. Aramburu, I do note that you have a conflict immediately of that Memorial Day week. So not saying anything will be scheduled, just saying those are the notional things, and there are many more factors to take into account before we pick any hearing dates. I want to go at this point then and talk, Ms. Chase, with the applicant on its thoughts and concerns, other issues that I should be taking into account as we set up the hearing dates, and then I'll do the same for all the other four parties. So Ms. Chase, what are the applicant's thoughts on scheduling, given what we've just talked about for the other requirements?
Sure, thank you, Judge. This is Ms. Chase. I think first, Judge, I think Mr. McMahon and I were conferring during the break, and we realized that we had inadvertently lined up all of those potential deadlines to be on Mondays, and that it may be more humane for everyone involved to have those occur either in the middle of the week or at the end of the week. So I'll just flag that, and I think that was reflected maybe in some of your comments about how those were the earliest possible dates, but it may be that we adjust them by a few days here and there.
Okay.
So with that, I think as for applicant, we would like to make sure that there is a deadline built in by which parties would need to file motions to strike any testimony to which they objected, and time for resolution of that prior to the pre-hearing conference, or I'm sorry, prior to the hearing itself. I think that's similar, or I was looking at the kit task order that you cited in your agenda for that that concept, and that's where I'm drawing that from. So I think that's one consideration. And then another consideration that the applicant would like to discuss is whether it makes sense to tier consideration of some of the issues in terms of the hearing date or the filing deadlines, and specifically whether it makes sense to have a separate set of deadlines for a land use adjudication as opposed to the other issues that the parties may raise.
Okay, so I think I understand fully the second portion about maybe separating the land use and then the conditional use permit issues from the other items. Well, restate for me that first concern again, and you referenced the Kittitas Valley order. I'm going to ask staff to see if they can solve that echo. Ms. Chase, let's see if we can get you unmuted and answer about that first item that the applicant was raising.
Judge Torm, this is Andrea Grantham with EFSEC staff. I went ahead and muted both of the phone numbers that called in, but I believe Ms. Chase was one of those. If they want to, they can unmute using *6 or #6.
Thank you, Ms. Grantham. Maybe we'll hear Ms. Chase's voice here shortly.
Are you able to hear me now?
Yes.
Yes.
Great. Thank you. So Judge Torm, I apologize for any confusion there. I can answer your question about that first concern.
Okay, go ahead.
It's simply that the case schedule should include a deadline by which parties who wish to file a motion to strike any pre-filed testimony would have the opportunity to do so and an opportunity for a response. And so what I'm proposing is similar to what's laid out on page 9 of the KITTF scheduling order.
Thank you. I think honestly in my multitasking, my ears just didn't pick up some of what you were putting down there.
No
Okay.
problem. I think I explained it more clearly the second time.
Thank you. Mr. Harper, let me come around to you at Benton County and see just generally where you are, having heard my comments and discussion with Mr. Aramburu to some extent, and now from Ms. Chase on scheduling for the county's needs.
Right. Thank you, Your Honor. Ken Harper for Benton County. On scheduling issues, Your Honor, I guess I want to split my comments into two categories. One, I think the county is likely to share what you're probably going to be hearing from Mr. Aramburu when we turn to sort of more of a a date setting range sort of concept, because we do have some serious concerns about the viability of a set date right now. Setting that aside, not trying to go too much further afield into that area. The other concern I've got with the proposal from the applicant is that when we were coordinating earlier this on these topics in our letter, I think the expectation of the county, at least, was that it would be likely that the sort of sequence of events would be worked backward from the actual set date of the hearing. That isn't to say that it isn't perfectly viable to do it this way, but what it does lead to is just simply the reality of a set of materials coming in possibly as soon as April 3rd. And to Ms. Chase's point regarding availability, I can tell you that at least in some parts of the state, the first week of April is spring break. And so that makes it very difficult to imagine coordinating what could be a very intensive effort in a very short period of time. And in fact, perhaps even shorter than the 28 days might nominally suggest. And I'm very concerned about that, Your Honor, because it wouldn't just be a matter of spring break on the calendar. It would be a matter of the existing workflow obligations of witnesses and counsel and party representatives, which can be much more easily managed and kind of integrated with new expectations if those things are all set somewhat out. But if these things are likely to be occurring as soon as the first week of April, I can just foresee that 28-day period is not functionally usable as a 28-day period. It may actually turn out to be a 20-day period or 15-day period, and that starts to seem like it's not necessarily consistent with what the parties were thinking with the 28-day interval when we collaborated in our earlier letter to you. And certainly it does start to raise questions about the fairness and the ability, at least of my client, to respond. That being said, if that April 3rd date shifts, then I think some of those concerns are significantly ameliorated. So, Your Honor, I'd like to speak to sort of the setting date in general terms. So I'm going to hold that because that's not what you're asking about right now. And if you have any further questions about our concern about the specific April 3rd date, I'd be happy to take those. As to Ms. Chase's point regarding potential interim events within that initial period, motions to strike, possibly tiered presentations, I think I'm agnostic on that. I understand some benefit to that. I don't think I have a strong position one way or the other there, though, Your Honor.
All right, thank you, Mr. Harper, and I appreciate all that you said. I wonder somewhat, many of the concern would persist even if we had April 10th be the date and then a 28-day period from there. So we'll see what we can do about the start date. As far as working backwards from a set hearing date and working the calendar from there, in my experience, not only in scheduling matters like this, but just 20-some years of being an administrative judge, I like to know what I'm trying to fit into the 5-pound bag. And if I have 10 pounds worth to put in it, picking a set date and then putting 2 bags in front doesn't seem to help. So right now, I'm just trying to figure out what kind of interval has to occur before the hearing date and today's date. And it sounds like at the very least, I've got nearly 2 months for testimony to, once the first round comes in, for the last round to come in. And I need time ahead of that for the first round to be filed. That may be a month from now. So we're talking about a 90-day period or so for evidence development and then a round of motions. So that's where my complication is. Before I pick a date, I've got to pick it far enough out. And as I mentioned earlier, the concern where Scout Clean Energy has the application extended for consideration only to July 8th as we sit here today. If we count back from July 8th 3 months, that gets us to about April 8th. And these are the dates we're talking about starting the filing of pre-hearing testimony. So once again, it looks as though the July 8th date, if that's the end date, if we were going to stick with that, and Ms. Chase and Mr. McMahon are certainly gritting their teeth wondering what they have to tell their clients about EFSEC's ability to meet this 12-month schedule, which is now already at I think probably 24 to 36 months. That July 8th date, if it has to move, they only want to move it the smallest possible amount out to the right on the calendar. And that's why, Mr. Harper, I'm trying to get a realistic discussion of all the things that need to be packed into that 5-pound bag I mentioned before I pick a date for the hearing that tries to comply with the July 8th deadline for, imagine this, even after a hearing, having deliberations and writing an order that has to be reviewable by the Supreme Court of this state. So to give this a quality and thorough evaluation, it's all the things I'm trying to consider and recognize today for all the parties as we just talk about the scheduling, let alone everybody's sincere concerns about the issues presented by the proposed project. Mr. Harper, anything further, having heard that little spiel?
No, Your Honor. In fact, that was what you just said is exactly what I was sort of thinking as I was making my comments, because I appreciate what you're trying to accomplish and the way you're going about it. I don't mean to throw us in a different direction. And that's why I say if it is important, as obviously you've indicated, to work forward from essentially the present day, we'll make it work. I would just appreciate some consideration for trying to manage this fairly intense series of events on a very short time frame, perhaps shorter than at least I was anticipating.
Yeah. I think it was the lyrics in a song from Smokey and the Bandit back in the day about a long way to go and a short time to get there. So we're going to do what needs to get done with all due respect to those things. All right, Mr. Harper, you can tell as I've moved to Ellensburg 5 years ago, in this town, we say it's not my first rodeo. Ms. Reineveld, what does CFE think about all the scheduling?
I think we're generally agreeable to the scheduling outlined. I think we would share Mr. Harper's concerns with coordinating expert testimony or potential expert testimony in response to the applicant's testimony in such a short window of time without sufficient notice to coordinate if the clock kind of starts ticking on April 3rd. And that's particularly true if we have another pre-hearing or multiple pre-hearing conferences in which we are still working on finalizing the disputed issues, because I think it's important to establish those sufficiently kind of before we start this schedule, and it is March 10th. So that being said, in terms of the specific hearing dates that were proposed, I am not available on May 15th or on June 20th. So that's just something to note for the record on those weeks. And then I would also agree with the accommodation in regards to, I believe it was the accommodation that expressed kind of a preference for maybe separate adjudication of land use and conditional use, and then other issues. Or no, I'm sorry, that was Ms. Chase for the applicant. So, so I guess those are generally our thoughts.
All right. Well, Ms. Reineveld, I was hoping as counsel for the environment, you would use your statutory powers to select experts who didn't have any other personal life and could just be at the beck and call of the council.
Yeah,
All right.
unfortunately, that is not the case. I do not have that sort of power. I wish I did.
All right. Well, I will put my tongue back firmly in cheek, and we will continue with the realities that we are faced with in scheduling. Let me come around to the Yakima Nation and Ms. Volkers. Speaking to what you've already heard and kind of the outline of dates we have, what are the Yakima Nation's thoughts on scheduling?
Thank you, Honor. Shona Volkers for Yakima Nation. A couple of thoughts. First, with fully understanding the timing constraints that you are working within, candidly, I do not believe that we can give this project its full due by scheduling a hearing on such a tight schedule. I would say that we, I think as a group discussed in our first meeting last week, and I think it still to me is a live question and would appreciate direction. I hear the discussion with what sounds like an assumption that the direct testimony that Ms. Chase says that she will be prepared to file in just 3 weeks would all be on the applicant to bring that direct testimony. And that was a question that we raised as a group in the letter on whether the other parties who are bringing specific disputed issues, whether they would be the ones to bring direct testimony with regard to those specific issues. And so it's a little hard for me to speak on the on that proposed schedule without that clarification. And if it is the applicant that's only responsible for bringing their testimony in 3 weeks, then that would be helpful to know. It feels hard to fully respond without having the issues in front of us. And I understand that that is something that we're going to work through, but especially if we may be having a second hearing to do that. Again, I just respectfully, this seems really ambitious. The last thing I would say, and we raised this, and I know, I'm sure that Your Honor is planning to address this, but we raised this with Benton County in our joint issue statement that we filed yesterday. And I think that the question of the schedule is tied to this threshold procedural question on whether this adjudication can really proceed without further progress on the SEPA process. So I will just mention that for now, since I know that that's not the direct question to me at this time.
Okay. Thank you, Ms. Volkers. First off, again, I want to say I wasn't a part of the collaboration, obviously, between the parties. I appreciate that they followed my direction and everybody did get together and hash things out as far as was done before today's pre-hearing conference. That helps to crystallize everybody's mind around just how ambitious this project is and just how complex an EFSEC adjudication can be when there are so many, at least as I anticipate, disputed issues. As to the filing schedule, the reason I've taken it today from applicant and everybody else responding is maybe just from my personal experience with this in the past, am I looking at this as a burden of proof and a burden of production question? It's the applicant that is making this proposal to the council to have a recommendation made to the governor. And I would think, again, I'm open to other ideas, that the applicant carries the water first, and then everybody knows what they need to respond to. The Yakima Nation will raise its own issues and be treated as though it's direct testimony, not necessarily all having to be responsive to the applicant, but you'll see what issues the applicant raises, and certainly independently, you'll set your own scope based on the scope of your intervention to file direct testimony that can just be on behalf of the Yakima Nation, and that would apply to any of the other three parties that are not the applicant. I hope that clarifies a little bit what's going on there. Everybody has independent full party status, but the burden of proving that the application should get a favorable recommendation and that all of the appropriate mitigation that might be recommended through the course of SEPA and other adjudicative processes really falls on the applicant. They're the reason we're here, and frankly, they're the ones that are funding most of this. So they don't get any extra points because they're in that position, but it's just another factor I and the council need to take into consideration as we go forward. Ms. Volkers, does that help on that point?
Your Honor, this is Shona Volkers. Thank you. That's very helpful. And I appreciate the clarification. I would add then that our request is that this be framed in the same way that it was framed in Order 790, so that it's clear that applicant's pre-filed testimony is the first one due. I would also, just again, given that our group's discussion on the 28 deadline was last week before we knew when the project applicant was going to propose bringing their testimony, I would advocate for more time, as is reflected in that Order 790, which was a smaller project than this one, and has a more than a month between the applicant's pre-filed testimony and other parties' pre-filed testimony deadlines in that case.
All subject to discussion and consideration. Thank you. On the question you raised about SEPA, and I don't really want to invite a full discussion with the other parties on this, so I'm not asking for anybody that speaks after you to come back on the SEPA question. I will say that the WAC 463-47060 addresses some of the typical concerns where folks don't understand typically or are not familiar with because it happens so infrequently. EFSEC adjudications are not about SEPA questions. The adjudication is a separate parallel track to what's going on with the draft environmental impact statement and the comment period on that recently closed. I'll admit that starting the adjudication, in my mind, would be premature if it's not informed by at least a draft environmental impact statement, and that's why I've pushed in the background to wait for this day and the petitions for intervention until there was something more in the public sphere than just the application for site certification. Having a draft environmental impact statement out after a full comment period and investigation by the contractor hired by EFSEC to do that work helps flesh out a number of issues that weren't immediately obvious in the original application for site certification. That said, SEPA is a separate track. And if you look at 463-47-060 sub 2, the administrative code that's been adopted and has been essentially the law, for lack of a better word, for years, says the council may initiate an adjudicative proceeding required by 8050-090 prior to completion of even the draft EIS. Final environmental impact statement, quite frankly, is not going to happen in this case, and it has not happened in past adjudications, including the Kittitas Valley case. That horse has left the barn, and I think that the Supreme Court has already ruled on that. If there's motion practice to be had on that to create a record for purposes of preserving that issue for further appeal, I have no problem with that. I understand that clients have legal interests that need to be raised at the trial level if they're to be preserved for appeal. But I want you to expect that given what the law is and the EFSEC's previous experience and what the Supreme Court has said the law at 8050 is, we're not going to spend an undue amount of time on that creating a record. It may simply be by written brief and a brief order that tells you again in writing what the law is. But as you'll see on item, I think it's number 7 on our list, under Civil Rule 11, you've got to have a really good reason to file something and a good explanation if you think you're going to move to change existing law. And I will hold you to that, even if the civil rules don't directly apply in an Administrative Procedures Act adjudication, as this will be held under RCW 3405. I'll give you some slack, some leeway on raising issues, even if they're not currently permitted under the current state of the law of the state of Washington, but we'll raise them and we'll dispense with them quickly. I'm not empowered as an ALJ to change the law. The council's bound by the law. The governor, up to you on what you want to raise for Governor Inslee to consider. So take a look at that and also look at 8050-090 sub 4, paragraph A, which lays out that the purpose of this adjudication is to hear from persons in support or opposition to the application on specific issues. And then again, we'll have a public hearing for those members of the public that want to comment outside of what we're going to adjudicate as parties. So Ms. Volkers, I hope that answers the mail a little bit on the question of where we are with the SEPA process. And I'm sure you will have opinions, and I will let the tribe and the Yakama Nation get those in writing in more detail. Today's not the day for us to litigate it, but I did just want to tee up where I'm coming from as the presiding officer from this, and I'm sure there will be disagreements perhaps with the substance of what I said and maybe the tenor of it. But for today, that's where I'm coming from, and I just wanted to be fully transparent and clear with you and your client and all of the parties that might have SEPA concerns, that the adjudication is a separate process outside of SEPA. Ms. Volkers, I guess it's only fair after that rant to give you a chance to respond.
Thank you, Your Honor. Shona Volkers with a brief response. We really appreciate that the adjudication is moving forward separately from the SEPA. Given WAC 463-47020's express incorporation of the SEPA regulations that we've put in our letter, as well as others, we request that there be a briefing schedule set on this issue. Thank you.
Thank you. And again, a briefing schedule is probably what's going to be appropriate, as I said, to raise all these issues at that hearing, adjudication, or trial level, however you want to look at it. Thank you, ma'am. Mr. Aramburu, on the scheduling question that we started here at the top of the hour and ended at the last session, what does Tri-Cities Cares want to bring to my attention?
Judge Durham, Rick Aramburu for Tri-City Cares. Really sort of three issues here. First, the question of whether the adjudication can proceed in the absence of a final environmental impact statement. That's an issue we're concerned with as well.
Yes, and Mr. Aramburu, I'll just ask you to be brief on that.
We will follow the briefing schedule as it's set, but we believe that is a motion that needs to be heard.
All right, so, you had two other points.
So secondly, this question about who submits testimony and when. There may be circumstances in which a party who seeks to carry a burden of proof on an issue needs to present testimony, original direct testimony, not in rebuttal. And I will just give you a brief example, which will probably play out here. Tri-City Cares, as the applicant knows, is very concerned with aesthetic issues here and believes that conditions should be set regarding the aesthetic impact of this project. And we will argue that certain things should happen with regard to this project as a result of that testimony. So the testimony would come in would really be kind of direct testimony from us, not necessarily in rebuttal to the testimony from the applicant. And so it may be appropriate in certain circumstances that direct testimony be submitted on those issues, because the testimony on visual issues, we don't know what they're going to say, but it may not be strictly rebuttal testimony. It may be testimony that is original testimony, not going to rebuttal. And that may be true for other issues as well. So I think we need to kind of address that issue as well in terms of the scheduling. we also have a concern, and I just want to express it now as well, that the draft impact statement did not consider the amended ASC that came in. It's a little unclear when it came in. The council seems to think it came in on January 3rd. So that is another SEPA issue, probably subject to a briefing schedule. So I guess my suggestion on that score would be that that you set up a briefing schedule for the SEPA issues, and we can get those aired out at this point. The third question is whether there would be a separate proceeding on the land use issues. I know that's occurred in other cases. I don't necessarily have a strong feeling about that, but that has occurred in other matters. So those would be our three comments.
Thank you, Mr. Rambrew. I'm definitely open, maybe not to calling it a separate proceeding, but on having topic-specific dates scheduled for the various issues that are going to be raised, so that perhaps I wouldn't call it bifurcating the hearing in any way, shape, or form, but because it'll all be going under the umbrella of the adjudication. But having topic-specific or issue-specific dates, or perhaps a series of dates, makes sense to me for segregating out those witnesses that have nothing to do with environmental impacts, but are simply there for the land use aspects or some other example that's bound to come up. And again, as I think I said to Benton County on the scheduling count issue, as well as the Yakima Nation, I share your view that as much as the applicant has the burden of proof and persuasion on getting the project to a favorable recommendation to the governor, it can be direct testimony that comes in from the other parties. Just because we've talked about direct reply and rebuttal, I think, again, as lawyers, we appreciate the technical meaning of those terms. And it's in this context, I'm not trying to imply any granular meaning on those other than everybody gets a chance to present their case, and as parties has a chance to present their full case. And that's how I'm going to approach it, Mr. Aramburu, regardless of kind of the labels we've kicked around informally this morning. I hope that addresses at least some of the concerns on that topic. What do you think?
I think that would be perhaps a good idea. Certain issues would be considered at certain times, and witnesses and all the witnesses who presented on that subject would be heard at one time. That might help focus the council in its deliberations and not have an extended time between subject matter for the council's review.
All right, sounds good. Ms. Chase, I think it was you, maybe it was somebody else that referenced Order 790 and a particular part of that order that you found potentially transferable to this case. And I thought someone said page 11, but I'm on, well, maybe I do have 11 pages. Call my attention back to where we were looking at that.
Sure. So Judge Torum, I was looking at page 9, apologize if I misspoke, and paragraph 4, motions to strike pre-filed testimony.
Thank you. I have that in front of me now.
Yep. And then I also think that paragraph 2 is helpful in terms of the schedule for pre-filed testimony in the sense of addressing some of the issues that Ms. Volkers and Mr. Aramburu raised of having other parties who want to submit pre-filed direct testimony have a deadline by which they are required to do that.
Thank you. See, my memory of what happened many years ago in Ellensburg was right, but I had not been able to find that page with all the other multitasking going on. Thank you for helping me with that. So for all the other parties that haven't had a chance, having just got the agenda this morning and my reference of Order 790 somewhere, I think it was on page 3 of the agenda for under item 7, That order gives you an idea, at least of how I've done this in the past. I'm open to suggestions for improvement always, but that should also, Mr. Aramburu, answer some of the mail that you and other parties that are not the applicant have raised this morning. So let me sum up where we're at. As we're at 10:35. We've talked a little bit about the challenges of trying to get things scheduled with the existing July 8th deadline for the extension of the application at this point to that date, as well as your calendars. We've also talked a little bit about the desire for pre-filed testimony and how long it takes to get things to work, and to have a good substantive presentation ready for the council members to review, to hear, and otherwise. And we've talked a lot about how that should be done, whether in-person, hybrid, or the preferences for virtual as currently stands with the direction from our chair. Because I can't tell you, I don't want to set a date today, but I do want to, at this point, do what I think is maybe some low-hanging fruit. Our filing requirements, as I shift to number 5, and we're not done with number 4, we're going to circle back when we're under number 6 and 7. On item 5 about filing requirements, the EFSEC procedural rules as they still stand from pre-COVID require a lot of things to be filed and copies made in paper. And I know that's helpful for some. I've resisted printing out a lot of things today for lack of printer ink and also environmental sensitivity. I'm not sure in which order. As an old school lawyer, paper's still great, but only to a certain extent. And the burden of filing pre-filed testimony with 12 or 14 copies would clear forests, I think, in a case like this. Does any of the parties feel strongly that we must require service with paper copies from you to all of the other parties, knowing that if I do, the burden will be equal on all of you if you have to file multiple copies with the council and multiple copies with the parties? I'm going to start with the applicant and just ask about the question about electronic versus paper. And before I do, I want to see if Ms. Massengale is available to talk a little bit about the electronic filing and the requirement for using the specific EFSEC email box that we set up for this, and frankly, her experience that not everybody has been doing that so far in the process. Ms. Massengale, are you available?
I am. Thank you, Judge Torm. So again, this is Lisa Massengale for EFSEC. I would just remind everyone and respectfully request that any email communications, whether it's filings, letters to Judge Torm, etc., that they please copy the adjudication email that was laid out in the order commencing agency adjudication. We are having instances where copies are maybe going to other EFSEC staff, but are not actually going just directly to John Thompson and the judge, but are not actually going to that adjudication email. And in order for us to officially receive and process those as records, it's really important that you please copy that adjudication email. So thank you very much.
All right, thank you, Ms. Massengale. And I think you actually sent me an email while we're on the call here, wondering where one of the letters is from the parties that we've been talking about today. So I'll send that over to you as soon as I can identify it, and that way you'll have a copy. But again, formally, parties, sending it to everybody else on an all-party email and sending it to me, I certainly appreciate. But please put this EFSEC or adjudication@efsec.wa.gov email together, and that will guarantee that Ms. Massengale knows what's going on as well, and we go from there. All right, let me come to you, Ms. Chase, and see if there is input on that as well as the electronic versus paper copies.
Thank you, Judge, and thank you, Ms. Massengale, for that clarification on how the parties are to address correspondence. We'll be sure to do that going forward, to use that adjudication email box, and that was really helpful for us to hear that from you. In terms of your question, Judge Torm, about email copies, we're fine with dispensing with paper filing requirements and using email copies. I think what we would propose is that the parties confer and settle on a a firm listserv of whose emails for each firm should receive those, including, you know, if there's, for example, a designated support staff person who should be included. And applicant would be happy
Pardon
to
me
leave
just a
that.
second. Ms. Chase, whatever you said after that firm listserv,
Oh.
at least on my end, came out garbled. I want you to repeat that if possible so the court reporter has it fully clear. I'm not sure if her audio had the same problem as mine.
Happy to do so. So we're happy to dispense with paper filing requirements on behalf of applicant. In terms of electronic requirements, our proposal would be that the parties confer, and applicant is happy to lead these discussions to generate an agreed upon listserv of who all the lawyers at the firm and any support staff at the relevant firms may be who should be copied on any particular filing. And then we'll have one uniform set of addresses that everyone can work from for all filings, which will of course include the adjudication filing address.
I'm going to ask if Joan Owens from EFSEC staff is still on the line. Ms. Owens? She might be on mute. She might have not been able to stay for the whole conference. The reason I called for Joan just now is because in the lead up to today, Ms. Chase, we were trying to do the same sort of question about where are we sending out like today's pre-hearing conference agenda? What kind of list did we need? So she had developed a listing as well for the applicant for Benton County, for Council for the Environment, for the Yakima Nation, and for Tri-Cities Cares. And so, like Mr. Arambaru has two different email addresses that she has listed, and Council for the Environment has not only Ms. Reineville's address, but also a Julie Doloff and a couple of other, one other email address there. I think working with Ms. Owens as the parties develop their own agreed list of who gets served if we go with electronic service will help make sure who else on EFSEC staff should get served those documents in addition to the copy that's going to be required for the adjudication address. So I will let Ms. Owens know if she's not listening now that I'm dragging her into the midst of this establishing the filing list. And if she's not the correct point person, we'll establish who is to work with the parties.
Judge
Does that
Torm,
sound
this
good,
is
Ms.
Lisa.
Chase?
Judge Torm, this
Go
is
ahead.
Lisa Massengale at EFSEC. I actually compiled that list. And that was based on the email addresses that were provided by the parties in their initial filings.
All right. Thank you, Ms. Massengale. I wasn't sure. I think I got that from Joan last night when we were getting ready to send out the pre-hearing conference or the preliminary order on intervention. So thank you for the clarification. You may very well be the person monitoring those things. So if you are, excellent. All right, turning to the next party. Mr. Harper, you're up on this question of paper and electronic copies.
Your Honor, Ken Harper for the county. We would be happy to facilitate and coordinate in any way electronic filing and service and dispense with paper.
All right, thank you. Ms. Reineveld, on behalf of the environment.
Yes, so we are in agreement. Council for the Environment has a preference for electronic, both because it is less burdensome and also because it is more environmentally friendly. And as Council for the Environment, we are particularly concerned with the adverse environmental impacts of an in-person hearing that would require the parties to produce written copies and also to travel long distances just because of the climate impact. So I'm definitely in favor of establishing an agreed list.
Okay. For the Yakima Nation, Ms. Volkers.
Thank you, Your Honor. Yakima Nation strongly supports electronic service and filing.
Okay. Mr. Arambaru for Tri-Cities Cares.
Electronic service and filing is fine with us.
All right. Well, let me call on Mr. Thompson as our Assistant Attorney General and the one that I conferred with about this last night. I think, Jonathan, that we are going to have to take a look at what the EFSEC rules are and maybe get a stipulation to the parties to differ from what the written WAC might be. So we probably just need to make sure if all parties agree. As a judge, I'm just thinking about getting burned later if we deviate from the established WAC and some party then criticizes EFSEC for doing so, even though we might have all agreed to do so. I don't want to be accused of ultra-virus activities later, but I do want to make sure that we have some mechanism without having a formal APA rulemaking to deviate from the rules we have. Mr. Thompson, any ideas on how we can move toward an electronic service and filing requirement and minimize or dispense with paper altogether? And if I'm putting you on the spot too much, Mr. Thompson, we could take this discussion outside the pre-hearing conference, but I'd just like your initial thoughts on the mechanism.
Yes, thanks, Judge Torm. I don't think there's any anything that would be required other than what you've already heard today, which is the parties' agreement on the record of this pre-hearing conference that electronic filing is sufficient for their needs. So and service. So there may be more details that would need to be worked out. I'm not sure, but I wouldn't have any concerns from deviating from the procedural rules just based on the discussion you've had today.
All right, as you told me, I have to think a little bit more inside the box from time to time. So I want to make sure I'm not too far outside the lines when I'm trying to be creative and do what I think is right, and despite what the rules might say. With that in mind, then, I think we'll work with Ms. Massengale and EFSEC staff to develop that list that Ms. Chase first referenced, and maybe I'll have Ms. Massengale send a copy of that list to all of you today. And by the time we get around to our next pre-hearing conference, which I'm sure is going to be necessary, we can formalize that. And I might still draw up, being a little old school on the cover your six, as we said in the military. I think that's acceptable in mixed conversation. Make sure that we have a stipulation that, and the representatives from each party can formally sign off on it. So those are the ground rules for going forward in this adjudication. They may differ in another adjudication, so I just want to be specific. We'll have the transcript from today, but if I summarize it into a quick one-page stipulation on filing rules, I think that'll give everybody a quick reference to make sure that they know what they're doing, and we can append the approved service list to that stipulation, and everybody will be on the same page, or pages literally, even if they're electronic. All right, I see we are coming up on our second break. We still have a little bit of work to do. And frankly, it's the hardest part is going to be this development of disputed issues, but it may not take a lot of time today because I've read what the parties have submitted, and we're nowhere near the degree of specificity, and we're nowhere near the neutral tone that I'm hoping for that might be set out in orders like number 790. So with that in mind, I just want everybody to refresh what their thoughts on disputed issues lists are, and how we're going to come up with one by agreement between now and the next pre-hearing conference. And we'll come back at the top of the hour at 11 o'clock. I'm going to try to have us wrapped up by 11:30. If we need to run longer, I know I put this on my calendar to run up until noon, but I'd prefer if we didn't. I'd rather give you the other half hour back before the lunch hour so that those of you on the line can call and confer with each other about how it went today. But we'll also be selecting another date for a second pre-hearing conference. I think I have time the afternoon of Monday, March 20th in the afternoon, and I may also have some time coming Tuesday morning, the 21st in that week. And it's possible I can also make time on Friday, March 24th, depending on how I juggle some other parts of my schedule. So take a look at those dates. I may also be able to give you March 22nd. I'm just frankly juggling another case there that I'm not sure how it's going to go in my other job. So here we are at 10:49. Miss Allison, if we take a break until 11, is that good for you?
Yes, that's fine. Thank you.
All right. Thank you. With that preview of issues, we'll go off the record and take a recess until 11 o'clock. It is now 11 o'clock. We're back for a third hour, hopefully not the full hour, with our pre-hearing conference number 1 and the Horse Heaven Wind application before EFSEC. Do we have Crystal Chase back?
Good morning, Judge Torum. Yes, this is Crystal Chase.
And Kenneth Harper?
Ken Harper for Benton County is present.
Sarah Reineveld?
Sarah Reineveld for Council for the Environment is present.
Shona Volkers?
Shona Volkers on behalf of Yakima Nation is present.
And Richard Aramburu?
Rick Aramburu present for Tri-City Cares.
All right. I'm hoping that one of my cats is not going to make a noticeable appearance as well, but she's looking like it. Let's proceed with the question we've got here about the disputed issues. All right. Well, this is where Judge Torum puts on a little bit of a scold, disappointed hat. I was really, really hoping for a better set of disputed issues from the parties today by agreement. As you can tell by the way the agenda reads, I don't think we really got that. We got some fairly vague ones. We got some very, very biased toward the interests of the parties presentations. I'd love to save that kind of argument for briefing, whether oral argument or written briefing. And I know everybody's passionately involved in their perspectives and the issues for which they're going to spend a lot of money and a lot of time adjudicating these issues. But when we're developing an issues list, the council has yet to form their impressions, and they need to be given a clean set of issues and then evidence on which to base their opinions. So I'm just going to ask, when you go back to collaborate further, that you keep that in mind and find those common points of agreement or just the basics of a topic, so we can say, as Mr. Aramburu pointed out, and frankly, if you look at his email, I'm not sure, Mr. Aramburu, who all you sent it to, I think it was all parties, that identified environmental impact issues that Tri-Cities Cares is concerned with. That's the kind of issues we need, at least as a nugget to start with, and not some of these tilted questions that only have one answer. That's for a legal brief. That's not for a set of disputed issues. So most of what I read in the submissions that came in on March 9th didn't meet the standard that I want to set out here in number 7 on our agenda, and sort of what you've already seen in Order 790 from the Kittitas Valley case from a long time ago. I still think that case carries some lessons procedurally that I've learned over the years and applied, and that the parties here would get some insight if they don't have the experience with EFSEC on how to present the issues at this stage of the proceeding. Plenty of time for opinions and strong feelings later. We'll all deal with that. But right now, as we collaborate and try to frame the issues, we need a little bit more neutrality and a little bit more common ground on just what the council needs to consider. And I know all 5 parties have different approaches, different interests, and will be advocating strongly. Put off your advocacy hats for the moment. Take a look at what I've recommended here and go back to the drawing board. And hopefully on the next round, I'll get from you what I need, and we'll be able to work on the substance of them at the next pre-hearing conference. If I don't get what I need from the parties, then I'll consult with EFSEC staff based on your inputs, and I'll draw up a list of disputed issues, and I will present it for your review. But after I take your comments on what I would draw up, that will become the ordered list of issues, and subject to your interlocutory review to Chair Drew, that will be the list of issues. So I'd much rather have the parties control the proceeding than me as the judge. I want to be much like a sports referee where maybe I'm throwing the flag, but I don't want to influence the outcome of the game. I just want to be the gatekeeper of the evidence that comes in, and I want to make sure we all play with the agreed set of rules, and I'll call the penalties accordingly. So I'm sure I've mixed up about 12 different analogies, but I think I've told you where I'm coming from. Let me now see what the parties think about that. Ms. Chase, from the applicant's development of this list of issues, is there something that you want to draw my attention to that the applicant wants to present today as, yes, this is clearly, although you have the application, everything might be at issue. Is there something specifically the applicant sees and knows is going to be in dispute that should be on the issues list?
Thank you. This is Ms. Chase. No, Judge Torum, applicant is prepared to, meet its initial burden as to the application itself, but really sees this as a process by which the other parties to the proceeding identify what specific issues might be disputed. So I don't have anything specific to draw your attention to today.
All right, fair enough. Mr. Harper, on behalf of Benton County.
Well, Your Honor, Ken Harper for Benton County. Yeah, it's been helpful to hear your remarks, certainly, Your Honor, because I did not perceive the issues list in Order 790 to be, frankly, particularly specific or targeted in a way that I guess seemed to track what the county thinks the actual disputed issues in this case will be.
I will defer to you, Mr. Harper, that list is not as specific. It at least identifies which portions of the environmental impacts by name, but it doesn't have the degree of specificity the county was filing with the tribe in its letter yesterday. We could have more detail than 790 as long as the tones are neutral. So I don't mean to say you can only go as far as 790 on detail. That, like I said, I've learned some things since then, and a little more specificity up front in that proceeding would have helped. So let's build on that, but it's a good starting point.
Well, okay, thank you, Your Honor. Ken Harper again. I guess what I was getting at, Your Honor, is we're just trying to calibrate this as we were going, and we didn't find a WAC that specifically identified how to formulate issues. And our concern was that if issues are not expressed in a way that we think captures what we want to demonstrate, then we might have boxed ourselves out in some respect. But I again, Your Honor, I appreciate your comments, and we can certainly collaborate and go back and try to refine the statement further.
All right. Well, thank you, Mr. Harper. And that's really all they are, is my comments. And I don't believe there is an EFSEC rule that develops kind of a model standard. This is all Judge Torum flying by the seat of his pants in prior experience. So take it in the manner it's intended, just to help the parties come to some kind of agreement on what's there. I appreciate that. Ms. Reineveld's next for CFE.
Yeah, so as an initial matter, the parties, when we conferred, did request, Judge Torum, that you provide additional direction as to the scope, specificity, and neutrality of the.
Did we lose your audio?
Oh, can you hear me?
Yeah, start again. You said specificity and neutrality, and then at least on my end, it dropped.
Oh, okay. I'm sorry. So yes, I can continue. So I think we did request additional direction as to the scope, specificity, and neutrality of the disputed issues. And from Council for the Environment's perspective, it would be very helpful for you to provide some additional direction as to how to formulate issues, maybe a couple examples of issue statements outside of the order that you've referenced. From our perspective. So we have not yet submitted issues because we were waiting for that guidance. But I'm happy to speak generally if it's helpful to kind of the general nature of the issues that we see as disputed, if that's helpful.
It is in its own way. Let me digest that, and in the meantime, ask Ms. Volkers on behalf of Yakima Nation.
Thank you, Your Honor. Shona Volkers. We were coming at this with a similar perspective to Mr. Harper, and so this is all very helpful discussion. I would also echo what Ms. Reineveld had said. Our goal is that we are clear in what the questions are, so that we can be preparing the right scope of evidence and witness testimony, and that's our goal. So that was the goal in getting thoughts on paper, and certainly we can take this feedback back with us and look forward to working with the group But I would also appreciate any further guidance on how you see this kind of more general list that's in order 790, how, as you said, improving upon what's learned so that we can identify with more specificity the issues and still present that in a neutral fashion.
Okay, Ms. Volkers, I think I'm hearing from everybody that if I would draft a couple of issues that I would think would be suitable for the council based on just one topic, maybe that would be helpful. Is that sort of what you're asking for as well?
I think that would be helpful, and I mean, we're certainly committed to workshopping this as a group, and so and not putting this on you, and so we're dedicated to workshopping this as a group. But yes, if that's something that you were able to provide, that that would, I think, be helpful for those of us that are speaking up on the need for clarity.
Okay, well, I'm happy to take that on because I think if I can give you better direction on what I'm asking for, I think we were all in law school where it was the bring me another rock school or hide the ball. I'm not about that particularly. I don't want to waste anybody's time. So I'll give some more thought to what is it I'm really asking the parties to do. I'll sit down maybe with Mr. Thompson and some of the other staff that are interested and draft up a sample issue. What I'm afraid of is I don't want anybody to read too far into Judge Torum's personal styling of an issue and think, oh, they have to all be modeled like that, or, oh, that shows I'm afraid it might show a bias or prejudice that could be used against me. And I'm not trying to express any bias. I want you all to know I get no vote on this Horse Heaven Wind project or anything else. I'm simply a presiding officer making rulings on the evidence that the council has to consider. So if I style an issue, I'm going to try to keep it as neutral and in the middle as I can. But if you pick it apart, I'm sure somebody will find a word choice or something else to say, well, look at Judge Torum. He's leaning this way or that. I'm not. I'm really not. I don't get a vote. My opinion doesn't count except on evidentiary rulings. So I just, there's a little bit of a hazard if I wade into this, Ms. Volkers. I hope the parties appreciate that. But if that's what's going to help you and make this process easier and better and more efficient, I'll do it. With those caveats understood by the parties, to not take any opinions or microaggressions or whatever you can read into it too seriously. They're not intended. Maybe they're revelatory in some other way, but I've just tried to be of help to the parties in that regard. Let me turn to Mr. Aramburu at Tri-Cities Cares and see on the issues and the statements. And again, I've given Mr. Aramburu props already for going a little bit a step behind or beyond what the other parties submitted. And maybe you're more along the lines of the Order 790 level of issue statement, Mr. Aramburu, but I'll let you tell me what more you think.
Well, I think as we do issues, this is a suggestion of mine, that we want to make sure the parties understand as they prepare testimony that what the issues in the case are. And so, for example, no one is going to ask EFSEC to consider whether or not the impacts of the Chinese balloon falling on this project are going to be. That's not going to be an issue. But people
I certainly hope not.
Okay, well, I'm sorry for being facetious, but it's getting towards the lunch hour. But I think it's really a matter of notice to the other parties to make sure that we know what the subject matter is. Tri-City Cares filed 110 pages of comments on the draft impact statement, so our views on these issues are well known to the parties. So I do think that looking at 790, that's the kind of thing that gives us notice, and we can also use that set of issues to do the kind of thing that we were talking about before, which is maybe taking a day and say, okay, this is going to be Agriculture Day, this is going to be Wildlife Day, this is going to be Aesthetics Day, or whatever day it's going to be, that we have the witnesses on subject matter present. So I think 790 or some version of that is fine. But again, I think it's notice to the council, to the other parties of the issues that we're concerned with. And being too tight as the growth board is and some other people are with issues. I don't think that's appropriate here, given all the background, particularly from my client, as to what their concerns are about the project. The applicant knows perfectly well what we're worried about. So that's my thought. And I think helpful to have some example, or if there's another pre-hearing order, Your Honor, that you could direct us to, that would be helpful as well. So that's my thoughts.
Thank you, sir. I appreciate that. And I will look for other pre-hearing conference orders that might be a good demonstration. Again, I did what I could with the time I had budgeted left for this, but I think I'm going to ask the Assistant Attorney General, John Thompson, maybe one of our citing specialists like Amy Hafkemeyer and Amy Moon, who's handling a lot of the issues on the SEPA side, to sit down with me and maybe others that are interested in EFSEC staff and craft a bit of a list that I could send to all of you and go ahead and share that in the next week or so. And if I can provide it to you ahead of your next collaboration, I'm sure chronologically that's best. So I will get to work on that as soon as possible. Was there anybody else that wanted to say anything more on the issues we haven't resolved today? I think if I go back over the agenda, clearly number 1 was easy, number 2 was easy, number 3, I have your opinions and my homework to go to Chair Drew. Number 4, on the scheduling, we know sort of where the boundaries might be now. Number 5, I think we set up and we just need the stipulation that I want. Number 6, the pre-filed testimony timing, I think, got wrapped up in our discussion of number 4, and now we're on number 7. We're going to have to come back at a second pre-hearing conference to handle, I guess, numbers, whatever the response is to number 3, and that will inform how we wrap up 4, 6, and 7. So that's what I'm thinking the agenda for next time will be, what I find out from Chair Drew. We might even get that announced or discussed at next week's EFSEC meeting, depending on when I might have time to speak with her. If not, it'll be at our next pre-hearing conference. And then we can handle the other issues that are fallout in 4, 6, and 7 on today's agenda. Ms. Chase, was there anything else you think we needed to address today or to put on the agenda for next pre-hearing conference?
No, Judge Forum. I think it would be helpful at the next pre-hearing conference, maybe if you came if you're able to come with a set of ideas about proposed dates that the parties can further react to in terms of really pushing us to get our schedule in place once we get our issues list in place.
All right, and I may be able to get that, Ms. Chase, as part of when I send out the list of specific issues. I may be able to include a separate attachment with some more realistic ideas on dates, given what I've learned from all of you today. And on that note, for all of you on the line today that haven't filed notices of unavailability, as Mr. Aramburu took the liberty to do, which prompted me to start thinking about, gee, I wonder what the lawyer's needs are. I'd invite you to take a look at your calendars. It sounds like from my notes earlier, late May. And why don't you go ahead, despite the July 8th deadline, and tell me your availability all the way out to Labor Day in early September, maybe through the end of September. If you have any unavailability from late May, say Memorial Day, through the end of September, let's get it filed so that at least I know what your preferences are. I am sure that when I lay all these on a calendar together and the council's availability, we'll never be able to have a hearing that suits everybody and the dates, but I'll work to do that my best if you get me those dates sooner rather than later. Today's March 10th. If I could get your notices of unavailability, at least your preliminary ones, by next Friday, that'll help me to start cobbling together a schedule. All right, back to the original question. Mr. Harper, I'm up to Benton County.
Thank you, Your Honor. Ken Harper for Benton County. Your Honor, I would benefit, I think, from hearing just a little bit more on issues, and I just want to ask for clarification. I'm looking at Mr. Aramburu's statement right now, and if in fact the level of sort of specificity that Mr. Aramburu submitted earlier this morning is consistent with Your Honor's expectations for formulating issues, then I certainly get it, and I can tailor the county's position accordingly. Is that a fair read, Your Honor, on where you're coming from?
I'll say again, I think it's a good starting point. And when I'm pulling up his email again here, again, Mr. Harper, to say, he says he wants to particularly emphasize certain things like visual and aesthetic resources, the impact of wildlife species and habitat. For that particular one, again, speaking off the cuff, if there are particular species, as opposed to just the general habitat and species question, that would be helpful. I understand from the environmental statements that the ferruginous hawk is a species of great concern for many and may be impacted by this project as well as other raptors. But, you know, that kind of a listing or a grouping, whether it's a specific species of concern and a specific impact that might occur to that species, that would be a better granular detail so we'll know up front what the parties are expecting. I think in the spirit of what Mr. Arambu said, of the parties all knowing what the issues are, that's the ultimate goal. If that helps, Mr. Harper.
It does. Ken Harper again for the county, Your Honor. It does. I think on behalf of the county, we felt compelled to respect your request to get issues together, but obviously we do have an outcome that we would like, and we do have a preference for a result. So I think in formulating those issues, we were trying to be candid about the way we think those issues will be developed. But what I'm getting is that we can still do that. We just need to be a little more, I guess, as you put it, neutral or generic in how we express it. So I think that's helpful. I'm trying to draw out some comments, Your Honor, so when we go to a conference of counsel, we'll be able to channel what you're asking for a little more precisely.
Always dangerous to channel the mind of Judge Torum, but I appreciate that, Mr. Harper. I think I can just ask you to put yourself in the seats of this council and say, how do we tee it up? And from your perspective, to get the result you want, but how do we tee up the issues in a way so that those people that have a vote on the outcomes that all of you want, and they're disparate outcomes, let's admit it, how do we tee it up in a way that all of the evidence will get considered and they'll see it our way later? Let me depend on your advocacy for that, but this is not the time for advocacy so much as just getting the scope of the issues with enough so that the council says, aha, these issues, the issue statement are a good opening statement of what the evidence will show at hearing. That's the spirit that I want you to work on the next round of collaboration, to be inclusive about the issues, flesh out things that, by doing so, you're going to find some areas where you agree there's no way a project goes forward without a particular mitigation. Now, a degree of mitigation is something to argue about, but when you're developing the issues, you'll say, on this issue, as the application stands, even the applicant might be saying, yeah, on second thought, we want a different layout of the solar array, or we want a different spot for the battery storage, or whatever the granular detail might be. That might result in a stipulation on a particular issue because you've talked about it at this level up front, and it will save you from having to present a witness or present briefing. This is the time to look for those areas of agreement. I hope there'll be some, minor as they might be, but something will come out of the council of counsel, as you put it, to result in some meeting of the minds on just what the council for EFSEC needs to hear and what they need to really cover to be fair to all of you and the public on what the recommendation to the governor consists of when this is all said and done some months down the road. Mr. Harper, anything further on channeling my mind there?
No, Your Honor, actually, Ken Harper again for the county. That is very helpful to hear you on that. I think that'll guide the attorneys quite a bit. Thank you.
All right. Ms. Reineveld, CFE, anything else that we need to carry over to the next one or thoughts you have?
No, nothing further from Ms. Reineveld. Thank you.
Ms. Volkers, on behalf of Yakima Nation.
Thank you, Your Honor. Shona Volkers. First, I wanted to note that counsel for recommendation is available the week of March 20th, all the dates that you mentioned as a potential second pre-hearing conference. Second, we will submit written notice of unavailability, but I want to note now that I am unavailable the last week of June. And third, if not today, and I understand that I'm asking for something outside your agenda, but if not today, then we would ask that the next pre-hearing conference for a discussion or any perspective that you could share about how you would like to handle discovery and subpoena practice.
Okay, fair enough. We'll take up discovery next time. I think Order 790's one of its topic lines was order on discovery. That should give you some insight into what past practice has been, but no guarantee of future performance, if you will. But I'll add that to the agenda for next time, gladly.
Thank you, Your Honor. I did see that in the order and look forward to discussing further.
If nothing else, that will be food for thought and discussion next time, Ms. Volkers. Thank you. Mr. Aramburu, any last thoughts on agenda items for next time or anything else we need to cover today besides picking a new next date for another pre-hearing conference?
On the next pre-hearing conference, March 20 is open for us. March 21 is not. There may be some depositions that land in that week, but right now I'm available on the 20th and not the 21st. So I think that there is an issue that I think the parties ought to consider here is that I'm looking at the processes and procedures found in Order 790, and quite frankly, I'm not sure we can do this and get a council decision by July 9. That just seems very difficult given the circumstances here. Can we schedule and look at things to take us out some period of time after that? I just don't think we can get all this stuff done and get a council decision by July 9. It just seems impossible.
Well, Mr. Aramburu, sometimes we don't all call out the elephant in the room. And on my military time, I was Captain Obvious for some period of time before promotion. It's really up to the applicant to see whether they think that the July 8th extension they've applied for and been granted will allow the council to do what's legally necessary in this amount of time. I know I'm giving a really strong hint here, and you can guess what it is. And I know that Mr. McMahon is gritting his teeth because he has to go back to his client and say, maybe we need to file a third extension, but I can't direct that. That's, again, above my pay grade. But I appreciate what you're saying. The applicant has clearly heard this today. They now have something substantive to take back to their client to ask or not. Whether Chair Drew or the rest of the council will make the same realization that you've stated on the record today. Again, I think it could occur, and I think we may get some movement on that, but I also am respectful that the applicant's been waiting a long time, and so have the people of Benton County, and any further extension we go out to compromises those interests of getting an administrative process that the governor of this state still believes is the best way to cite these projects and have them evaluated. That 12-month statutory period, as I said, turns into a legal fiction, but it is the law. And reality is different than the law. I'll say that, Mr. Aramburu. I hope that captures what you're saying. All right.
Your Honor, it does. Yes, indeed. So.
All right. Well, we're both smiling then. Remember this day, because who knows if we'll be frowning at each other later. Let's go ahead and see if we can pick a reasonable time. I hope that next week, given that it's already March 10th, and next week involves at least some festivities for some on Friday for St. Patrick's Day, if you'll have enough time to collaborate next week, and if I work hard to get you something maybe Monday or Tuesday. Just looking at my schedule for Monday, it's already overburdened, but I'm going to try to draw together EFSEC staff if I can for a meeting early Tuesday to work on or comment on anything I can pull together between now and Tuesday morning to submit to you for your collaboration. So if you're going to want to collaborate again, hopefully I'd have something to you by midday on Tuesday, the 14th of March with my items, and you can find some time between that point and the Monday afternoon that I have available for a pre-hearing conference. I would suggest maybe 1:30 to 4:30 as a whole, but let me go around the room and see if that is available for everybody. Ms. Chase, for the applicant, would our next pre-hearing conference, March 20th on a Monday, starting at 1 or 1:30 work for the applicant?
Yes, it does. This is Ms. Chase for the applicant.
All right, same question, Mr. Harper.
Ken Harper for Benton County, that's fine, Your Honor.
2 for 2. Okay, Ms. Reineveld, keep the streak going.
That is fine for Council for the Environment. Thank you.
And Ms. Volkers, I don't think that you said you were unavailable the 20th. It was the 21st, right?
Thank you, Your Honor. Shona Volkers, we are available all the days you propose, and so certainly 1:30 on the 20th works for Yakama Nations Council.
Excellent. Mr. Aramburu?
We're available at the March 20 from 1:30 to 4:30.
It is my lucky day. That'll be it. I will have EFSEC staff send out a similar notice that you got for today's conference, and with whatever the call-in information will be. I'm not sure if I'll bother with the Microsoft Teams next time, wasting time waiting for my computer to fail me again. But we'll meet again March 20th. I'm going to make a note to try to, again, I'll send an email to our staff after we hang up today to not only send out the notice formally, but you've got it on the record today. And we'll also try to get you a couple of example issues fleshed out, and perhaps also the other homework you wanted from me besides issues. Would somebody speak up and remind me, besides examples of issues, what else you wanted?
It was Ms. Chase, which is who's speaking now, and our request was simply that if you were able to sketch out a tentative proposed schedule, that would give the parties something to react to at the next pre-hearing conference. Yeah.
Okay, thank you. I will see what I can do with that, subject to the limitations that exist for the July 8th piece. Right now, as it stands, if the applicant, Ms. Chase, chooses to come back and somehow let the parties know that that might be a flexible date, and to what extent, who knows. But again, I'm asking all of you by next Friday on St. Patrick's Day to get in the notices of unavailability, and just in case, have them run out till September 30th. Mr. Thompson, let me ask you if I've left anything off that you think I needed to raise today with the parties, if you're still on, John.
Again, yes, I am, and nothing that I can think of that can't be taken up at the next pre-hearing conference. Thank you.
All right, and council, I'll do my best to crystallize this agenda a little bit more and send it out next week with kind of what we've agreed on and worked through and workshopped today. So you'll have it more than 5 minutes before you get on the line. Again, I apologize for doing the just-in-time supply chain approach to this work, but I'll try to catch up a little bit in the days ahead. I'm going to go around the horn one more time and see if there's anything else. And then if parties would stay on the line, simply for the court reporter to ask for spellings of anything we've pitched at her today so the record can be a little cleaner. Anything else for the applicant, Ms. Chase?
No, thank you, Judge Torum. This is Ms. Chase.
And for Benton County, Mr. Harper, anything else for the record today?
Nothing further. Thank you, Your Honor.
All right, Ms. Reineveld?
Nothing further. Thank you, Judge.
Ms. Volkers?
Thank you, Honor. Nothing further for Yakama Nation.
And Mr. Aramburu?
Good to go. Thank you.
All right, EFSEC staff, anything else for the record today? And you don't have to speak up if there's nothing. Hearing nothing, then this pre-hearing conference is adjourned at 11:35.